SJC-11702, Commonwealth versus Henderson.
Good morning, Mr. Shedd.
Good morning. My name is Dennis Shedd, and I'm representing Frederick Henderson. This is an identification case where the two eyewitnesses, Shante Griffin and Rondale Williams, testified that they did not know who the perpetrators were. So instead of in-court IDs, what the jury heard was Ms. Griffin's recorded interview and her grand jury testimony in which she stated that Jigga and Drano were the perpetrators, and she identified photographs of Frankie Herndon and Frederick Henderson as those two people.
The Commonwealth says this is not an identification case. I think that's a central tenet of the Commonwealth's brief. The Commonwealth's position is this is a credibility case because Ms. Griffin knows the perpetrators.
Well, I want to address, I'll take that in two steps. This is not simply a credibility case. That's the same position the motion judge took below. They claimed this is only a credibility case, and ID expert wouldn't have made any difference. So let's assume the witnesses were lying at trial when they said that they couldn't identify the perpetrators, and in fact, they believed they could identify the perpetrators. Well, that doesn't mean their identifications were accurate. Instead, that raises the same questions that come up every time a witness makes a good faith effort to make an identification. Did the person have an adequate opportunity to review, to observe what they saw? Were they capable of recognizing them, recalling what they saw? Did anything happen between the time of the incident and the ID that could have affected their memories? Was the ID procedure suggestive?
I'm not saying the Commonwealth is right in their position because I think Ms. Griffin's testimony is, even though she might have known the defendant for quite a while, she had only seen him on not that many occasions, maybe 3 or 4 occasions. So I'm not saying that the Commonwealth is right in their position, but if they are, the issue is not whether or not they had enough time to make the observation. Their view is, no, this is somebody that she knows, and so the identification procedures don't help saying, well, does he look more like number 1 than number 7 in the array?
Well, first, I agree that she claimed she only saw this person known as Drano 3 or 4 times.
So maybe
over the
it
previous
is.
year,
Maybe
over
it
the
is,
previous year.
and maybe it is an identification case.
Right, but so 2 points there. One is there's good reason to believe she thought Drano was somebody other than Frederick Henderson. The jury heard her tell the detectives that Drano was just a short guy. Later in the trial, they heard that Frederick Henderson is 6 feet tall. Now, a center on a basketball team might think a 6-footer is short, but not many people would. The next point is that, and that discrepancy is something counsel never pointed out. Second thing is the jury heard Ms. Griffin say that Drano is shorter than Jigga. The jury never heard that Frankie Herndon, like Frederick Henderson, is 6 feet tall. So if, as she said, the second perpetrator, who she says is Drano, was shorter than Jigga, then one of her identifications has to be wrong because these guys are the same height. And the third thing is, as you just mentioned, that she says she told the detectives and the grand jury that she'd seen Jigga almost every day for 1 or 2 years. She'd seen Drano 3 or 4 times over the past year, every time with Drano. Now, at trial, she looks at Frederick Henderson sitting there and says, I've never seen this man before. Clearly, the jury didn't accept that. But counsel could have presented documentary evidence proving that Frederick Henderson could not be the person she had seen for the past year because he was in prison until 3 months before this incident. And the document showing that is in the Appendix 3 at page 5. He was in prison. She could not have seen him over a 1-year period. Now, putting that aside, the fact that there's good reason to believe she thinks Drano is somebody that is a different person altogether, she has serious opportunity to view issues in this case that were never presented to the jury. First is the distance issue. So she is standing 110 feet from where the shooting takes place, and an expert would have testified that the ability to recognize a face at that distance is near zero. This isn't just your standard ID factor that makes it more difficult to make an ID. This suggests that if you've been watching this entire incident unfold, perfect viewing conditions, she could not have recognized the faces of the men there. Second issue is the timing issue. Only 20 seconds elapsed from the time these two men got to the walkway to the house until perpetrator 2 began running away after the first shots were fired. Now, the resolution of this surveillance video is way too poor to view the faces of anybody. But it appears when she's talking to you can see her talking to the neighbor across the street. And it appears when she's facing that neighbor, her head appears dark. And on a couple occasions it lightens when she turns to one side or when she starts to run down the street. Her face looks a little lighter. And counsel never pointed out that it appears from looking at that video that she only glanced in the direction of the incident after those first shots were fired, at a time perpetrator 2 was already running away with his back to her, which would suggest that she never had an opportunity to see that person's face. And an expert also would have said, that's contrary to what most lay people believe, is that the ability to remember an incident decreases with the time to view it. So not only does she have serious opportunity, even if you think she was familiar with her, these serious opportunity to review problems suggest that she never had an opportunity to see that person's face, and in any event, she was too far to even recognize the person's face. Now, turning to Rondale Williams' alleged identification. Yes?
Before you leave Ms. Griffin, the 110 feet,
Yes.
where does that come from?
That's an expert study that was done by Jeffrey Loftus and another person in 2005. It's attached to the, it's in the appendix there.
Okay, but I'm referring to the testimony of that she was that far away. Was that measured out by somebody?
Actually, after trial, I went to the City of Boston's GIS Boston mapping, and it shows where number 6 is and the indentation where the porch was, where Miss Griffin was talking, and it shows number 11 down here. When you measure that out, it's 109 point something feet.
So this is not evidence that the jury heard?
No, this is not evidence the jury. This is evidence that could have been presented to the jury, but they did not hear that. That's right.
What did the jury hear as to the proximity of Ms. Griffin to the shooting?
This is it. So Ms. Griffin originally reported that she was standing at number 14 where she lived, basically across the street from this. That's not true. Then they found the video evidence, and it shows her standing in front of number 6. So the jury heard she's standing in front of number 6, and it took place at number 11, and there was an exhibit presented showing the street, but there was no scale on that, and there was no testing about how far she was standing from number 11. But they did see that map showing here's number 6, here's number 11, and there was the video showing where she was and where the incident was.
So the video shows her at 6?
Yes.
And she testified that she was in front of 14?
That's what she initially said. She was in front, either 14 or 12, which is basically just straight across. That's where she originally said she was, straight across the street, essentially.
Initially, did she change her testimony?
After, when she first spoke to the detective, and I believe at the grand jury, that's when she said she was at number 12 and number 14. Subsequently got the video in a trial. She acknowledged she was talking to the neighbor, Blondell Sandifer, and Blondell Sandifer testified about where she lived. And the video showed her standing in front of number 6.
6. Okay, so the jury would have understood that she was in front of 6.
Yes, I believe so.
And were there any diagrams or any photographs of the scene that would enable the jury to see how far away that was?
Again, there was a chart entered into evidence showing it. My memory is it didn't have a scale on it. I don't recall. Even if it did, they didn't have any testimony telling them that the ability to recognize a face at that distance is near 0. But there's certainly no testimony at the trial how far, nobody got up and said number 6 is X feet from number 11. There's certainly no testimony like that. But there was a chart entered and there was the video evidence.
And was it argued? Was it argued that she was too far away to see him?
No, there was no argument that she was too far away to recognize it. That argument was not made.
All right. Now, I guess it would have been problematic for your predecessor counsel to have said you couldn't have seen him for a year because he was in prison until 3 months before the shooting. So there's a strategic reason to not bring that out. What do we do with that?
Well, I guess I think you could have brought that out. I mean, if she's saying she saw this person for a year and she could not possibly have seen that person for a year, I see no problem with bringing that out. You know, that certainly could have been brought out. And in any event, even if you don't want to bring that out, you still got her saying she only saw him 3 to 4 times in that previous year, which is certainly not somebody who is familiar. You know, you can't say, this is a person who's well known to me. That's certainly not the case here. But personally, I don't see a problem with bringing out he happened to be in prison. There's no evidence of what the charges were at that time. Though you just say, you got a document saying, here's where he was, and here's the date he got out, which is May 28th, about 3 months before this incident occurred. So she could not have seen him for that time.
And when she said she saw him, she said she saw him on the street. She didn't see him in prison.
No, she said she saw him on the street with, each time with Jigga about 3 or 4 times in the previous year. That's where she said she saw him.
Within the previous year, right?
She said, she was asked, how long have you known these guys? A year. And she said that a couple of times in the interview with the police, that she'd seen these 2 guys together for a year, as far back as a year, seeing Jigga every day, almost every day, and Drano 3 or 4 occasions for the course of a year. Yeah.
Okay, and when you were about to turn to the testimony of the other person.
Yes, Rondale Williams, as far as his alleged ID. Now, certainly he knew Herndon and Henderson for a long time. He was standing a few feet from Mr. Barnes when the shooting took place. He described himself that day as being mad drunk. It was the day of the Caribbean Festival. He'd been drinking vodka throughout the day, smoking marijuana, using other drugs. He testified that shortly before the shooting, when he was on that porch, he was focused on smoking and rolling marijuana, and in fact, other witnesses testified they saw him smoking marijuana at that time. And the video, you can see him constantly moving his hand up to his mouth. He testified that once the shooting began, his focus was on that gun, and then in a panic on trying to get away. Now, lay people tend to believe that stress in the presence of a weapon focuses attention and it burns details into memory. The jurors never heard that research shows the opposite is true. Stress significantly decreases the ability to make an accurate identification. And the studies have also shown that people, when confronted with a weapon, do exactly what Rondale Williams said he did. They look at the gun,
all
not
those
the face.
studies are for people who are identifying people they don't know, right? You just told us that Williams knew these guys.
Yes, Williams definitely
All
knew
the
the
studies
guy.
you're citing are all identifications of strangers.
Well,
These studies don't account for people who know people.
Well, the studies are looking at where is your attention. The point is, where is your attention
I
focused?
get the studies, the gun focus and all that, but those are all stranger cases.
Right. But the point here is that to be able to say, this is the person I saw, you must have looked at that person's face. And what he says is, I'm focused on rolling and smoking marijuana, and then the shooting starts, and my focus is on that gun. And the studies show that's what happens. People look at the gun, they don't look at the face. So that's the point, is if he's looking down here and then looking at the gun, which is what he said happened, not looking at the face.
Is that the grand jury testimony, the trial testimony, or both?
Williams was consistent at grand jury as at the trial. He said, I don't know who the perpetrators were. I talked to other people and heard from other people. That's what he said at the grand jury. The only evidence of the ID, of his alleged ID, is the testimony of the 2 detectives about this unrecorded interview. That's the only evidence he ever made in ID. So his grand jury testimony was consistent in that respect.
Mm-hmm. And he's known them since
He'd known them for years.
2005.
He'd known them for about 8-10 years, as I recall. So he certainly knew them. The question is, did he ever look at and see those faces? And that's the point where an expert could have made a significant contribution here, because what the researchers show is that when you're faced with a gun, people do exactly what Williams says they did. They look at the gun, not at the face.
That point's important for you for another reason as well. I mean, the weaker Williams's ID is, the more prejudice there is on your ineffective claim as it relates to Griffin's motion to suppress, the motion to suppress in Griffin.
Yeah, as far as the motion to suppress...
Not filing it.
Huh?
Not filing it, right?
I'm sorry.
Was there a motion to suppress ID relative to?
No, there was not.
And that's one of your ineffective assistance
That's
claims?
one issue I've raised.
So what
yeah.
I'm saying is, when we look at that claim to see if it's a substantial likelihood, assuming it was a failure to file the motion,
Right, well,
the prejudice from that is a function also of how weak or strong Williams's testimony is. So
That's
the
right.
weaker Williams' testimony is, the stronger your claim on substantial likelihood for failing to file the motion to suppress ID.
that's right, that's right. I mean, so my position there is, if you look at the motion to suppress, are you confident that a jury would rely solely on Williams' alleged identification, where the situation is you've got, the only evidence of it is the testimony about 2 police officers, about an unrecorded interview. He's consistent in all his recorded testimony with the grand jury and the trial. He says, I don't know who the people were. He's intoxicated, and he says, I've never focused on the faces. I'm looking at my marijuana, and then I'm looking at that gun in a panic, trying to get out of Dodge, as he put
Now,
it.
but I may not remember this correctly, I think I do though, but the trial counsel for the defendant provided an affidavit at the motion for new trial in front of Judge Sullivan.
He did.
Indicating reasons, including the booking sheet, and including another independent witness who talked about the perpetrators actually being about 6 feet.
Well, as far as the motion to suppress, trial counsel said 2 things. One, he said, I think a motion to suppress would have failed because there was a dispute about how well she knew Mr. Henderson, Drano, basically. So that was one of his reasons. And that my argument as to that is that the evidence is pretty clear. She did not know him well, and if you don't know the person well, you use an array, not a single photo. And the second thing he said was, I didn't want to tip off the Commonwealth to lines of cross-examination. And my point there is that's ridiculous. That's clear. That's manifestly unreasonable, because it was obvious this was an ID case, and it was very clear what the cross-examination was going to be like if her ID came in. Certainly, if the photo ID was excluded, there would be much less cross-examination needed.
I guess what I thought was part of the issue, though, was that the booking information has him about the same height, right?
Well, that's something I presented on the motion for a new trial.
And then there's an independent witness who has them at about the same height, who doesn't identify who they are, but provides an identification. Not an identification, but what the person's height is and what they look like.
Shante Griffin is the only witness who testified about the heights, and she said, Drano is just a short guy. He's shorter than Jigga. That's what she said. There was nobody ever said these 2 guys were the same height. There was no evidence of that. It's only Shante Griffin saying Drano's just a short guy, shorter than Jigga.
Were they in the courtroom at the same time so that the jury could see them?
I'm sorry, I couldn't.
Did the jury see these people?
They certainly saw them sitting at counsel table. The jury was certainly never asked to compare the heights of these 2 guys. Whether they saw them standing next to each other at some point and took note of that, I have no way of knowing that. But certainly they were never asked to have these guys stand up and compare their heights. That never
Right,
happened.
I guess I was talking about Foster, right? Foster?
Bernard Foster, yes.
Right, doesn't Foster say that he's
No,
about
what
about
Foster-
6 feet? Hold on,
No, he did not.
He didn't
what
say that?
Foster said that one of the perpetrators was 6 feet tall, about 6 feet tall.
One of the shooters.
But it's very clear from the testimony when he said that he's talking about the guy who came back and shot a second time. And the guy who came back and shot a second time, that's Jigga. That's the one who's been identified as Frankie Herndon. So he's talking about Frankie Herndon at that point. He's talking about the second guy. He never suggested what the height was of the first guy. I mean, the second perpetrator, the one who's been identified as my client, Mr. Henderson. Forrester never said anything about his height.
What did Griffin say she saw?
Well, Griffin, if you look at her interview and the grand jury testimony, it's painted as she watched the entire incident unfold. She says she saw them walk up the street. She saw Jigga they were standing next to each other. Jigga took out a gun, fired a shot. When the first shot was fired, Drano backed away into the street and then ran off, and she lost sight of him. Jigga started to leave, then came back, leaned over, shot again, and then ran away. Her testimony as far as where people are running does not match what the video shows, and her testimony differs from Williams in that she said she never saw a gun in Drano's hand. Williams said he thought there were 2 guns involved. In fact, the ballistics shows there were 2 weapons used, and she has people running in different directions, and I think it's pretty clear from the video. Certainly, she did not watch the entire incident unfold. That's I think it's pretty clear from the video.
So what do you do with it, Griffin, that she said who the shooter was by nickname before any identification? Doesn't that make it a credibility question? Didn't she say, oh, it's Drano before she
That
ever
it's
looked
Jigga,
at the single ID?
Well, she said Jigga and Drano in the phone call Detective Wise that day. And there's 2 points of that there. One point is that she spoke to other people who told her who they thought the perpetrators were before she spoke to Detective Wise. That's in evidence. So she heard from other people. Other people said they thought Jigga and Drano were the perpetrators. So the post-event information that an ID expert could have testified to is very important there. She could have heard that, incorporated that into her memory as something she had seen herself, and then reported that. That's one point. And the other point is the one I mentioned before. She may have heard people talk about Jigga and Drano on the street and thinks that Drano is somebody other than Frederick Henderson, who does hang out with Jigga. And that's why she thinks Drano is a short guy, shorter than Jigga. You know, there's good reason to believe she thinks Drano is somebody else, not Frederick Henderson.
Now, there was reference to Griffin having heard other people say the shooter was Drano. Is that in evidence?
No, there's evidence that other people told her who they thought the perpetrators were before she spoke to Detective Wise. So that's where she could have gotten her information that Jigga and Drano are the shooters. That's in evidence. But
there was, I guess, except implicitly, there was no testimony that others said that it was Drano who was the shooter. But I guess one could say that was implicit from that inquiry. That was on cross of her, or was that on direct?
That actually, she said that in her grand jury testimony. I believe it was her grand jury testimony originally. She was questioned about that, and she said, I spoke to 2 people about it, and at least one of them she said I spoke to before my interview. So that came out at that point.
How long did the jury deliberate?
Excuse me?
How long did the jury deliberate?
How long
did the jury deliberate? Was it
to
many
be honest,
days?
I don't recall right now. I've certainly got the transcripts here, but I don't remember off the top of my head how long they deliberated.
Okay.
Okay, thank you.
Okay, thank you.
Ms. Campbell.
Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. We ask you today to affirm the defendant's conviction for the murder of Derek Barnes after he violated the no snitching code. And I think that is essential to put this case and the testimony of the witnesses in context. I'll start with the question that you just posed, Judge Link, as to how long the jury deliberated. I'm not sure what time they got the case, but it looks like they deliberated for at least 2 full days, and they rendered a verdict on day 16, which would have been a 3rd day.
That's what I thought, yeah. Okay, thank you.
But turning to the central issue in this case, this is a case in which, sitting here listening to my brother's argument, much of it would make sense and be stronger if this is a case where the witnesses actually went to trial and made identifications. It's critical that they did not, and when judging trial counsel's performance, it should be looked at in light of that fact, that he had 2 witnesses, which all of the estimator variables that he was speaking about, those become less important when you have the individual on the stand that says, that didn't happen, I didn't see the shooter. To to focus on those things would be to highlight the fact that they had made an identification previously. It's reasonable to not want to highlight that fact. To answer questions posed by Justice Lowy about the motion to suppress, it's interesting because I'm not sure when you think about what would have been suppressed, it wouldn't have been the nicknames, because she said the nicknames prior to ever being shown any photographs. So if you were really just looking to suppress the identification of the photographs, that wouldn't suppress the identification of the nicknames. On that point, it's critical that other witnesses at trial testified, other witnesses who knew these two individuals testified that their nicknames were in fact Jigga and Drano. Even if you were to say that the motion to suppress would have been successful, when you're looking at the prejudice that they could have had in light of trial, it just would have been the single photograph, not the nicknames, and it really was the nicknames that were significant in the context of the case.
But this is an ID case. I mean, the out-of-court identifications of Griffin and Williams is your case.
It is our case. But I think it's important when you're looking, a lot of this was raised in the context of ineffective assistance of counsel. And so when you're looking at, in that case, what happened at trial is what you hope in an eyewitness ID case, is that the eyewitnesses get on the stand and they say, I was wrong, that didn't happen, that's not the guy. I'm not sure what more you gain when you have that evidence by attacking the identifications themselves. Really, when you think of it, what the jury was asked to do is say, okay, we have these out-of-court identifications, we have the witnesses in court. In court, they don't stand by that testimony, they don't make identifications. Really, should we credit what they do in court, or should we credit what they said out of court?
Yeah, but the whole thrust of the Commonwealth's case that led to the judge feigning so that in Commonwealth versus Day and Snero was that the credibility issue was, were they telling the truth out of court?
Correct.
But if you had an identification case, not this one, where the Commonwealth had presented an array of 4 people, all various, and the defendant was the only one in color and everybody else was in black and white, something outrageous like that, and for whatever reason, that came and wasn't suppressed, you certainly, and that came into evidence through a police officer, right? So the witness, like in here, doesn't want to testify. You're not suggesting that an expert witness wouldn't be available to come in and say, that array they gave is no good under our current science.
No, absolutely not. But I think
Because so the fact that it's not a court identification is one thing, but it's certainly subject to challenge by an expert in the proper case.
yes, it could be. It could be. And really here what the way that it was raised and what the court is tasked with asking is, when you have trial counsel, whether the decision to not present that type of evidence in light of the fact that you have witnesses not standing by those identifications is unreasonable. And I wouldn't say it would be, where it would be highlighting the fact that they made those identifications themselves. Also, I would say that
But more salient to your argument is probably the fact that these witnesses knew the guy.
Absolutely, absolutely, and that was the point I was just going to turn to. Shante Griffin obviously knows these witnesses less than Rondell Williams, but Rondell Williams does know these witnesses. To the extent that my brother pointed out that he testified at trial that he was mad drunk, to use his words, at trial, at trial, the jury had a video of the street, and the prosecutor did ask them to look at Mr. Williams, the movements he was making, and ask whether he was displaying such a level of intoxication that he suggested. I would suggest to you that when you look at the video, it undermines what he was saying when he was at trial, which is, again, understandable when you look at the fact that the animus and very motivation for this murder was the fact that the victim had testified and violated the no snitching code in a previous trial. So it's unsurprising that the witnesses who did make identifications would back away from those
But
identifications.
Mr. Williams, he didn't say anything about being impaired in his earlier statement, or did he?
He did, at grand jury, he had backed away from the statements that he did make to the police.
But how about the first one?
No, I think he did admit that he had been drinking and that he had been smoking, but not that he had the level of intoxication that he suggested at trial.
Okay. What about the defendant's position as to Mr. Forster? Is it clear, as the appellants say, is it clear that it's not Mr. Henderson?
I don't believe so, and I was looking at my notes of his testimony when he brought that up. It is clear that Mr. Forrester only sees one shooter, and he says that one shooter is 6 feet tall. My memory is not that it's that clear which of the one shooters that he is describing. But on that point, I think Ms. Griffin's the evidence about Ms. Griffin's testimony as to height, highlighting exactly what that was, and of course she wouldn't testify to that at trial, but what she, in the interview, what she said was, first she said that she believed Jigga was 6 feet tall and Drano was 5'8". The detectives that were interviewing her then asked to place that in context, and so they said and this can be found on page 25 of the Commonwealth's record appendix. They used one of the detectives as a comparison and said, "Do you believe that Jigga is the same size as him?" And he was 6 feet tall. She said, "Yes." They then said, Then the other detective then stood up and said, "And is Drano similar to size than me? Is he shorter than me? Is he taller than me?" And she said, "He's about the same size as you." And that detective was 5'10". So the difference in height was about 2 inches. There at least is evidence that the difference in height was about 2 inches, which really isn't significant when you think of the sort of observations and how they were being made.
So what do we do with the closing argument statement that the prosecutor said that Griffin had seen both of these guys on a daily basis?
Sure, and the Commonwealth concedes that that is a misstatement. She certainly had seen Jigga on a daily basis, not Drano. And when you're looking at the prejudicial aspect of this, the transcript of her grand jury testimony was marked as an exhibit and sent back to the jury. It was Exhibit 84, so they could read exactly what her grand jury testimony was with regards to that statement.
Okay, but that too was error to admit the transcript in evidence so that they had that written testimony and all the other testimony at trial was just oral.
Sure, I don't think it's any different than sending back a transcript of any kind of recorded interview that's given. Granted, Andrade came out after this case was tried, but I think if you look at Andrade and the sort of important aspects of Andrade are that if the substance of the grand jury testimony would have otherwise been admissible, then there really is no prejudice in how it was admitted.
So the prosecutor said that Griffin knew the defendant for 2 years or at least 1 year. The prosecutor must have known that Henderson was in jail. Is that a good faith statement?
Quite honestly, I don't know about Mr. Henderson's jail status. In terms of what...
I assume that, well, I guess we don't know, but I assume that the prosecutor had his BOP to know what his prior record was.
I would assume so as well. My brother mentioned that he had that in his record appendix, and I just have no memory of ever seeing that information, so I don't want to make a misstatement. It certainly is a reference as to what Ms. Griffin's testimony was. So insofar as she made that assertion, I would say it would be a good faith assertion because it's tied to her testimony, not the fact that he had indeed been on the street for at least a year. I'd also say that, she was not precise in asking how familiar she was with Drano. She was less precise, other than to say she had seen him 3 to 4 times within that year. So I'm not sure necessarily that precludes her saying that, in the 3 months prior. It would suggest that, she had made 4 observations in 3 months. that would seem to sort of be more recent in time and would suggest, I would say, a greater familiarity than just seeing it over an entire year. But even ignoring that, when you're looking at the prejudicial aspect of this statement in light of the fact that the grand jury testimony did go back in light of the evidence that was presented and the jury instructions that were given, it doesn't give rise to a substantial likelihood of a miscarriage of justice. I'm happy to answer questions about any other issue that was raised.
How about the 110 feet? I mean, it is troubling. I mean, I am aware of what the studies show. It was at night, it was raining. The jury never heard that matters. Is that an issue?
No, and I'd say my response is, I have 4 things to say in response to that. The first is that she got on the stand and said that she didn't know him and she didn't identify him. So that's the primary one.
But the jury clearly believed that she was frightened and didn't want to testify. So the jury had to rely, in view of their verdict, on what she had said to the police early on.
Sure. The second is that the jury in this case went on a view and went to those locations, and while not evidence, it did give them some context to put these locations in. The third is...
And on that view, will we see that the jury was pointed out as to where she supposedly was versus where the shooting was?
I believe they're pointed out to the... I don't believe that they're pointed out Griffin was standing here. They do point out the locations that are significant, yes. And they had video, multiple different angles of surveillance video, as well as maps and photographs of the area, so they were able to put in context what views could or could not have been made by someone standing at any particular vantage point.
3 and 4?
That was 3. As soon as I said 4, I forgot what 4 would be, so I'll rely on those 3.
That's okay, I missed one of them. The jury went on a view, the first one,
The jury went on the view. She recanted the identification at
that
trial.
one doesn't, as the chief suggested, might not matter. What was the third
Sure.
one?
The third is that they did have exhibits and evidence which they could look at by which they could understand the perspective and the relation of all these locations together.
All right, thank you.
Okay.
Thank you.